I'm joined today by Tracy Solet from International Managers Group and Dan Worthington from T. Rowe Price. I'll ask each of them to introduce themselves shortly. Before I do that, for those of you who don't know me, I'm Michelle Kirschner. I'm a partner at Gibson, Dunn here in London. My practice focuses on financial services regulation, particularly within the asset management sector across the liquidity spectrum, and also service providers to those asset managers. So I'll ask each of Tracy and Dan just to give a couple of words of introduction to themselves before we kick into the main body of the session.
Thanks, Michelle. I'm Tracy Zerley. I'm Senior Vice President, Senior Counsel at Affiliated Managers Group. I'm responsible for global legal and regulatory compliance for AMG and across our affiliate investment advisory firms.
Thanks, Michelle. My name is Dan Worthington and I'm Vice President Legal Counsel at T. Rowe Price. I sit in our London office supporting the EMEA business. I've been at T. Rowe for about 5 years and before that worked in private practice at Maples and Calder and DLA Piper.
Thank you both. So during the panel today, we're going to spend some time talking about Brexit. I'll take a straw poll from everyone as to when we might stop talking about Brexit. But we'll be focusing on issues arising from Brexit for asset managers, particularly in third countries, including now the UK. And as a result of Brexit, the distribution issues arising, reverse solicitation, and delegation changes potentially under AIFMD. We'll also be spending some time discussing sustainability, in particular the EU Sustainable Finance Disclosure Regulation and the UK proposals around TCFD aligned disclosures. Finally, and I hope that we will get there, we'll talk about the practical issues and challenges for managers relating to the Shareholder Rights Directive or the second Shareholder Rights Directive, particularly around engagement policies and the annual disclosure requirements. So without further ado, we will move on to Brexit. So the UK left the EU in January 2020, and the transition period ended on the 31st of December 2020, and therefore the UK is now entirely outside of the European Union. We therefore have a new relationship with the EU, and happily we have a trade and cooperation agreement with the EU, which, as many will know, was agreed rather last minute on Christmas Eve. As expected, that trade and cooperation agreement didn't really say very much about cross-border financial services provision between the UK and the EU. That wasn't a massive surprise. From the perspective of cross-border financial services, it's actually the Joint Declaration on Financial Services Cooperation and the Memorandum of Understanding that is envisaged under that declaration, which is far more important. The Joint Declaration envisages an MOU, as I've said, which should be agreed by the end of March. Mairead McGuinness, who's the European Commissioner for Financial Services, has really set out what the EU's view of the scope of that MOU is. And really what she said is that the EU is envisaging it to be a framework similar to that that's already in place between the EU and the US. In other words, a voluntary structure to compare regulatory initiatives, exchange views on international development, and discuss equivalence-related issues. What she's been at pains to stress is that it is not a means to replace the market access that the UK has lost as a result of Brexit. In other words, it won't be replacing the passporting regime. It's also not a means for constraining the EU's unilateral discretion in relation to equivalency. So as we know, European passport rights are no longer available to UK firms, putting them essentially in exactly the same position as third country firms in other jurisdictions, such as the US and Asian jurisdictions, etc. This slide sets out the various ways in which third country firms could access European markets. Passporting at the top there, as we know, is the sole domain of membership of the European Union, and it's very clear that the EU will not be permitting this via the back door for the UK or indeed anyone else. So in the absence of passporting, equivalence may be the next best thing. It's not a perfect solution by any stretch of the imagination, and we'll spend more time talking about that as we move through the session. So therefore, now that we've got a free trade agreement, attention is turning to equivalence. So turning to equivalency. Equivalency isn't a single decision that the European Union can make that gives the UK equivalency across the board. There's a patchwork of equivalency regimes peppered through European financial services law. Therefore, it's not possible for the UK or indeed any other third country to be granted equivalency in a single decision. The EU and the UK have already granted each other some limited equivalence in certain areas. However, I think you can really see those equivalency decisions being made really out of necessity to ensure that markets can continue to operate in the immediate aftermath of Brexit. And actually, it's very true to say that those time-limited equivalency decisions are by no means as wide-ranging as equivalency decisions that were in place already for other markets such as the US. My personal view is that the EU is probably pretty happy with the way in which things such as the share and derivatives trading obligations are working in the post-Brexit environment, given the shift of trading volumes into the EU markets. So equivalency decisions, if you sort of break it down, you can really see them being given for two broad reasons. First one is to enable EU regulated firms to apply the same prudential treatment to exposures to risks in equivalent third countries as they apply to risks in EU countries. And more relevant for the current discussion is to facilitate third country firms providing services within the EU. My view is that the EU is highly likely to be more inclined to only grant equivalency where it's strictly in the EU's interest to do so, essentially to enable markets to operate effectively, rather than to enable third country firms to provide investment and other services to EU clients in circumstances where those services could just as easily be provided by EU firms. And I think that will be largely a guiding principle for the EU. Consequently, I think whether the EU does exercise its discretion and does grant equivalency under particularly the MiFID third country regime remains to be seen as to what that might look like, not just for the UK, but more generally. The most important thing to note about equivalence decisions is that equivalence isn't a guaranteed outcome for the UK or indeed any other applicant for equivalence. An equivalence decision is not necessarily permanent. It can be withdrawn unilaterally, often with very little notice, and is absolutely not a replacement for those lost passport rights. And that's why I say that equivalency, whilst it would be nice and would remedy some problems, it is not a perfect solution. Now, in the asset management space, Brexit has posed issues for fund distribution, particularly, obviously, for UK firms as a result of the loss of passporting rights. It's a new issue for UK firms, but this has actually been a long-standing issue for third country firms. I think there's just an increased focus on the issue at the moment. So this side really sets out what the distribution landscape can look like for different firms and the options that are available. So I'll pause there and really take the opportunity to pose some questions to the panel and give them an opportunity to give us some views on the issues that I've raised. So at a high level, how have your firms been impacted by Brexit? What options did you consider, and what key factors influenced your decisions? Perhaps I'll go to Dan on that one first.
Thanks, Michelle. So from a T. Rowe Price perspective, we had decided fairly early on in our planning for Brexit that we wanted to play worst case scenario, so hard Brexit situation, and wanted to make sure that we were able to continue servicing our clients no matter what happened. So from our perspective, we did a bit of a restructuring. We already had a management company based in Luxembourg and have done for a number of years. But one of the things that we top up the licenses of that ManCo with MiFID permissions of discretionary portfolio management and investment advice, turning it into what some people call a super ManCo. We also moved our branch offices of our UK entity over to our Luxembourg entity, and alongside our sales staff to move our distribution function mainly to the EU. And then on the UK side, we established a new authorised corporate director for our UK fund range to guard against the ability of our Luxembourg ManCo being able to act as ACD to our UK fund range. So we were really guarding for a worst case scenario.
Okay, and Tracy, same question in your direction, if you don't mind.
Of course, and we had some of our firms take similar approaches in terms of establishing ManCos in jurisdictions like Ireland and Luxembourg. Our firms are largely boutique asset management firms, and some are multinational, and some operate from a single jurisdiction like the US or Canada or the UK. So the approach for each of these firms, depending on their size and scope, has really been dramatically different. I think economics and operations, frankly, have largely driven planning strategy. And for firms that have established presence in the EU, it's largely driven off of whether they have salespeople that are already present in a particular jurisdiction, or employees and operations that can support the requirements to be licensed in the jurisdiction. And some of our firms, frankly, don't rely on the marketing passport, and so they took a sort of wait and see approach.
And just having to think about equivalence, Dan, from your perspective, equivalence I don't think is a particular big issue for T. Rowe Price. Obviously, correct me if I'm wrong there. But question to both of you: how dependent do you see industry participants being on an equivalency decision from Europe, particularly under MiFID?
So I think that's absolutely right, Michelle. I mean, we restructured in a way that meant that we really weren't that focused on the equivalence decision, and it's not really going to affect the way we do business. But I think what you said earlier in your introductory comments about the EU really only being focused on giving equivalence when it's in their interests is absolutely right. I think it's quite unlikely if the UK diverges in its approach that the EU is going to be willing to grant equivalence.
I agree.
And actually,
and of course, for US firms,
No, go ahead, Tracy.
For US firms, you have been dealing with the third country issue for quite some time, and so I think there's some political aspects to equivalence, certainly as a result of Brexit. And I think any clarity given in terms of equivalence is going to be important beyond the UK, but certainly for other jurisdictions as well. It seems like a muddier path, from my perspective.
Thank you both. Dan, you touched on sort of the potential for the UK to diverge or indeed not, and sort of how that is tied in with equivalence. In terms of what you're seeing in your engagement with European bodies at the moment, and indeed within the UK, what's the thinking around, to what extent is the UK going to diverge from European standards? Obviously, there's been lots of discussion over it over time, very tied up with that equivalence decision, but just wondered, what is your thoughts around that? Are we going to stick to European standards? Are we going to essentially be law takers, or are we going to be brave and are we going to diverge?
Well, I think we're already seeing it, Michelle. I mean, I know we're going to come on to ESG and SFDR later, but it's one area where the UK said, no, we're going to go our own way with this. And we're certainly going to see some divergence there in relation to the regimes for ESG disclosures. I think that the UK is very willing to diverge from the EU in certain areas. I know that there was a HMT consultation recently where the UK was looking at what it can do in terms of developing its financial services regime to kind of bring in more investment from other countries. And to some extent, I think that was the whole point of Brexit, was to allow the UK to have some divergence. So I mean, I don't have a crystal ball, but I think we can expect to see the UK be brave, as you put it.
Thank you. Let's move on actually to reverse solicitation. Many people attending will have seen or at least heard that ESMA issued a statement on reverse solicitation back in January. It was surprising for many, less surprising for others. And that statement, just as a bit of an overview, was a reminder in relation to the scope of the MiFID II reverse solicitation rules, where the European Securities and Markets Authority has identified some questionable practices. And I think there were some examples given in that statement, but essentially what boiled down to overuse and misuse of reverse solicitation. Didn't specifically call out Brexit, but was clearly, had a political Brexit dimension to it. And I think one point that's really important to note with that ESMA statement is that reverse solicitation is absolutely still a legitimate way of accessing clients in the EU. It does not outlaw it. All that this statement does is demonstrates that the European regulators, ESMA, and going forwards the national competent authorities, are going to be far more attuned to proper use of reverse solicitation. And therefore firms relying on reverse solicitation would be very well advised to ensure that where they are relying upon reverse solicitation, they are comfortable on a client by client basis of the availability of the exemption, and documenting how you've got comfortable with that is enormously advisable. I'm always very skeptical. I was saying to the panel before we came on, when firms say to me that they've got a reverse solicitation strategy, or their marketing strategy for Europe is reverse solicitation. My view on that is, marketing strategy and reverse solicitation are mutually exclusive. Reverse solicitation really needs to be the sort of exception rather than the rule. But as I say, it is still a legitimate way of accessing the markets. And one thing that people have asked me over time, the ESMA statement only mentions MiFID. It doesn't mention any of the other sectoral legislation such as AIFMD. And obviously lots of third country managers from the US and other places will be selling or admitting investors into their fund on a reverse solicitation basis. The ESMA statement does not strictly, doesn't at all mention AIFMD, and therefore to what extent can we apply what's said in that statement to the other sectoral legislation such as AIFMD? Clearly there's no basis within the statement, but it's not a big hop, skip and a jump to apply the wisdom that the regulators are increasingly more focused on these issues. And again, for firms relying upon reverse solicitation from an AIFMD perspective, I think this statement is just another indication that regulators are focused on it. So again, just make sure where you are relying upon reverse solicitation that you are comfortable that it is a genuine reverse solicitation situation. So over to the panel again. First question, do you feel that this statement came out of the blue? Was it a surprise?
I think it was a bit of a surprise. And I agree with you, somewhat political posturing kind of in the wake of Brexit, making clear that ESMA is concerned about the questionable practices, and in particular, how those practices will arise, during this post-Brexit period. So it's interesting because in the absence of a third country regime under MiFID for third countries to actually market and provide cross-border services, people have been stuck in this balancing act for years. So I think there are a number of firms that take the view, not that it's a marketing strategy, but in certain circumstances, they do rely on reverse solicitation. But this type of scrutiny will put more pressure on firms and their compliance. I think the main thing is for firms to just be careful in terms of keeping good records, as you noted, but just making sure that they're not over-engineering reverse solicitation. I think if you have a program that's overly designed to document, I think you made the point earlier that some firms have documentation to support that they don't have, that the client wasn't solicited, and I think those are all good practices. It's just over time you want to make sure that those practices meet the expectations.
Yeah, I agree with that. Yeah, I totally agree with that. I think if you look at what ESMA is trying to achieve with this statement, I think they're really focused on firms that are trying to circumvent the authorization requirements, rather than firms that are actually using reverse solicitation as a legitimate method for providing investment services. I mean, some of the things that they pointed out was firms adding in clauses in their general terms of business that investment services were solely at the initiative of the client, that weren't really a true reflection of the actual fact pattern leading up to the provision of that service. So I think that that's really what they were focused on. But I totally agree, Tracy. Reverse solicitation is a legitimate practice in certain circumstances, but I think it should be construed narrowly, and it is only appropriate in certain circumstances.
Thank you both. And let's turn our attentions to delegation. I think, rather than being a backwards looking issue, this is a forwards looking issue. This is something that is coming down the wire that we are all going to have to pay some attention to. So many will be aware that the European Commission launched a public consultation during the course of last year, which is now closed, which was a prelude to its review of AIFMD and followed on from the Commission's earlier report into the impact of AIFMD. And it also followed the recommendations from ESMA, which were pretty wide-ranging, suggesting numerous changes to the AIFMD regime. The consultation itself ran to 102 questions on a broad range of topics. Of greatest interest to third country managers, and potentially the most controversial, is the questions around delegation arrangements. In relation to delegation, the Commission asks whether the rules on delegation should be made more restrictive by limiting what can be delegated to third countries, for instance, by imposing quantitative restrictions or prohibiting certain core or critical services and functions from being delegated, and whether delegate portfolio managers based outside of the EU should be required to comply in full with the AIFMD standards in order to manage assets under delegation. Essentially, the concern will be to ensure that rules prevent letterbox entities and that there is effective risk management within the EU of the funds. I think you can very much hear the politics here again, arising out of Brexit. Obviously, the EU not wanting the management of all of the assets to go back to London and wanting to bring that onshore into the EU. So this consultation is the first step of many towards a potential revamp of AIFMD. It's too early to gauge yet what the scope and the extent of any rule changes actually proposed by the Commission might be, but it's going to be an important issue for all third country managers who are managing under delegation from the EU. And the questions from the Commission do seem to give an indication as to the potential direction of travel. So third country managers are obviously going to be concerned about the delegation potential changes. And it's clearly going to be key for third country managers to remain on top of those and to remain engaged with the European regulators, be that through your own public policy or regulatory liaison teams or through trade bodies, etc. But making sure that everyone is feeding back to the EU on this issue is going to be really quite key in the coming period. So again, I'll open it up to the panel here, and just in terms of how important is the ability to delegate from the EU for each of your businesses?
Michelle, it's critical for T. Rowe Price. We're committed to our people in the locations that we have them, and our model, like many other global managers, really relies on the concept of delegation. I think it's really important for the industry as a whole and investors to be able to have access to exceptional investment professionals all around the world, without this without the ability without the issues that would be caused by onerous changes to the delegation rules, which, to be perfectly honest, I think the Commission has created a problem out of nothing. Really, there hasn't really been any issues with the delegation rules. So yeah, it was quite a surprise.
I agree. I agree. Delegation is important, certainly for all of our firms, and the ability to provide cross-border services from outside the EU is really, it's imperative. And I think just like reverse solicitation, it did come as a surprise, because to your point, there isn't any evidence of abuses stemming from delegation arrangements. So I think advocacy here is certainly something that is very important. And of course, in the process of commenting on this, the industry trades in particular have been very helpful. So I think nobody wants to see cross-border management mechanisms unnecessarily restricted. And so I'm hopeful that the engagement that we've had to date and engagement that we'll have in the future will hopefully shape this into the right outcome.
Thank you. Let's move on there, away from Brexit related issues. Actually, let's move on to thinking about ESG and EU SFDR. So the European Sustainable Finance Disclosure Regulation is but a part of the European Commission's ambitious Green Action Plan. However, it's the area of the plan that's currently getting the most attention, essentially because we've got an impending implementation deadline of the 10th of March 2021. In addition to the SFDR, the Taxonomy Regulation also sets out EU-wide framework according to which investors and businesses can assess to what extent certain economic activities are sustainable. Think of it as an EU dictionary of what activities may or may not be called sustainable. The Taxonomy Regulation also amends the disclosure requirements under the SFDR, although implementation deadlines for those changes is from 2022 onwards. There are also proposed changes to AIFMD, UCITS and MiFID in relation to building sustainability factors into investment decision making and related processes, which will apply to EU firms regulated under those directives. The EU SFDR, as I've mentioned, is only the first wave of the European initiatives aimed at reorienting capital flows towards a more sustainable economy, fostering long-termism and managing an increasing importance of sustainability risks. As the EU SFDR has the first implementation date, it's this that's currently receiving all the attention. So what does the SFDR actually require? First and foremost, and an issue that has caused an enormous amount of angst for firms all over the world, is how their funds are classified. So regardless of whether you are within the EU and therefore fully within scope of the SFDR, or sat outside of the EU but marketing your product into Europe, you need to classify your funds as set out on this slide. So Article 9 funds are sort of the most sustainable of funds, though these are funds which have sustainable investment as their investment objective. Article 8 funds, they're funds which promote, amongst other characteristics, environmental or social characteristics. And Article 6 funds are essentially anything that's not an Article 8 or an Article 9 fund. I should probably note at this stage that, as many of you will be aware, ESMA has written a letter to the Commission asking for certain clarifications. That letter was written at the beginning of January. We are now a week away from the first implementation deadline under the SFDR. We've not had any response in relation to that letter. Query whether or not we will get anything in advance of next Wednesday. We are only, as I say, only a week away from the deadline, and therefore firms are having to plod on with their implementation plans without that clarification that is so very needed for the industry. How a fund is classified then really impacts what the manager and the fund need to do in order to comply with the SFDR, as I've summarised on this slide. The SFDR requires disclosure of certain information relating to the approach taken to sustainability considerations, both at the level of the firm and also at the level of the fund. However, for those funds which are managed by non-EU managers and are marketed into the EU, it's not currently expected, and the market has accepted, that the firm level disclosure requirements won't apply in that case. So broadly speaking, the disclosures are required to be made either on websites, in the pre-contractual disclosures to clients or investors, and in periodic disclosures to clients and investors. So in the case of an AIF, for instance, those pre-contractual disclosures will be made alongside the Article 23 disclosures that we've all grown to know and love. And the periodic disclosures, where required, will be made in the AIF's annual report. So as I've already mentioned, ESMA have written a letter to the Commission regarding scoping issues and requesting clarification on a whole host of different issues under the SFDR. There are a multitude of uncertainties that still exist that managers are having to deal with and work through their implementation plans without the clarity that is so very much needed. A lot of the uncertainties that we've got stem from the fact that the so-called level 2 measures, which put the meat on the bones of level 1, haven't yet been finalised. We now have the final draft RTS, but those were only delivered quite recently. However, uncertainties still remain even once we've got the final draft of the RTS, and unfortunately the application of the level 1 requirements has ended up being divorced from the application date of the level 2 requirements, which is unhelpful for the industry. It's currently expected that the level 2 measures will apply from the 1st of January 2022, so at least there will be alignment with the next implementation dates. But that has really not helped with firms in their implementation plans. Some of the more important concerns around SFDR relate to what does it mean to promote environmental or social characteristics in order to be classified as an Article 8 fund, and exactly how sustainable does an Article 9 fund have to be. For example, unlike the requirements under the AMF doctrine, which many of you may be familiar with, there aren't quantitative thresholds for sustainable investments in an Article 9 fund. Questions around whether Article 9 funds can only invest in sustainable investments have been raised. Therefore, I'd like to open it up to the panel at this point, and just ask sort of where have the particular challenges been for you in looking at implementing SFDR for your firms?
Shall I? I'll go first because there have been a few, Michelle and Tracy. The challenges have come straight off the bat. If you look at the Commission's action plan on sustainable finance, and Michelle, you touched on the other parts of that, the taxonomy and the delegated acts. The sequencing was all wrong with that right from the outset. We have a disclosure regulation that requires disclosure about things that we weren't really doing. So it's almost as though the European Commission has called it a disclosure regulation, but it really goes a lot further than that. We've also got issues with the taxonomy and the definitions of what is a sustainable investment, not aligned between the taxonomy and the disclosure regulation, which will cause problems later down the line. And the delegated acts, the final text having not even been published yet. So kind of the operational and risk management processes to support the disclosures required by the disclosure regulation aren't in force yet. So I think the sequencing has been an issue. I think you touched on another really important issue, Michelle, which is how to define what is an Article and an Article 9 fund. I think that's between the Article 8 and the Article 9 is the one that's been, the Article 6 and the Article 8 is the one that's been causing the most challenges. And it really stems on what is the step up that's required to promote certain environmental and social characteristics. I think there's an expectation by the European Commission that really, as a minimum, it would like all managers to it would like all managers to integrate sustainability risks into their investment process. But I think what a lot of people have struggled with, and us included, is what does it mean to then promote certain environmental and social characteristics? So I think my overall feeling is, I mean, there have been many challenges, but that being able to categorize your funds properly is really at the heart of this.
I agree. We have a number of firms struggling with that challenge because the lack of guidance is making a number of firms actually a bit skittish about how to categorize their funds and processes. We have firms with dedicated products, and we have others where ESG is a data point, part of the analytical investment process. And everyone's concerned that they don't want to be second guessed. And so, you know, the two approaches that we've seen, some are simply categorizing themselves as Article 6 and providing a description of actually what they do. And others are that have a G component of their investment thesis, and they've got that all highlighted in their communications to clients, and their marketing materials are going ahead with the categorization of Article 8. But it's a challenge because nobody wants to be second guessed. And we were talking about this earlier. Nobody wants to actually have to categorize down in the event that the guidance suggests that they should be doing something differently in order to qualify.
Yeah,
and this isn't. Oh, sorry, Michelle. I was just going to say, and Tracy, this isn't just a problem for the industry either. That, you know, this is a problem for regulators as well. I mean, one thing that we've been hearing through our trade associations is that different national competent authorities are having some difficulties determining what the right approach is. So I think there's also concerns that you're going to end up with some divergence between certain CAs that maybe place a higher bar on the Article 8 versus others that might have a lower bar, and that could have all kinds of impacts, not least for the smooth operation of cross-border distribution. So I think that lack of clarity is really problematic.
Yeah, and when you've got a situation where firms don't actually know how to classify their funds, you know, that is the starting point of this entire regime. And if you can't even do that, it's clearly a massive problem. And to go back to your point, Tracy, around, you know, do you elect to go the Article 8 route with the risk that you might have to downgrade later, or do you go with the Article 6 and upgrade later if actually market practice, regulatory guidance, etc., indicates that you can? And many of my clients have taken the approach of, you know, they will go Article 6 for the time being, just simply because the thought of upgrading is a whole lot better than the idea of downgrading. But that comes with its own difficulties. You know, many firms are faced with investors who want Article 8 funds, and therefore, you know, there is a certain pressure, for want of a better word, to categorize as Article 8. But I think, you know, categorizing as Article 8 prematurely without having the infrastructure behind it to actually meet the requirements is a real risk, and not just a regulatory risk. You know, there's a real greenwashing issue there that is potentially, you know, a litigation issue for down the track from investors, etc. So I think, you know, that it's fraught with difficulties.
I think it's fraught with difficulties for managers themselves as well, because on the one hand, you have the desire to be conservative and certainly not to get ahead of the regulation if you're not entirely sure whether your process qualifies as Article 8. But for a number of firms, you know, ESG is part of their process. It's not necessarily the investment objective, but it's certainly a well-described part of their investment process. And they're being forced to choose Article 6 in this case, when, to your point, their institutional clients may have actually expected that they would, at the outset, categorize themselves as Article 8. And it's really the uncertainty that's driving that choice, not the fact that the investment process itself isn't ripe with ESG criteria.
Absolutely. I just changing tack on that one slightly. Obviously, where this regulation applies to third country managers who are marketing their funds into Europe, as Dan, you quite rightly said, this regulation is labelled a disclosure regulation, but it is so much more. It is causing managers to have a much more roots and branches think and put infrastructure in place around ESG frameworks, etc. What approach, and perhaps this is most question for you, Tracy, but obviously Dan, do feel free to chip in. What approach have you seen your firms taking, Tracy, where they've not got an ESG framework in place because there's no regulatory imperative to do so? What challenges have firms come across there?
I think it's, I think the notion that, you would comply or explain becomes a challenge. It's certainly it fosters conversation for sure. And I think a number of firms have found that, just with institutional investors and other investor demand, that they have been looking at their investment process and actually developing their sort of framework and statement regarding, ESG principles. But for some firms, it's actually challenging, even if you have ESG principles as part of your process. If you're, for example, a fund of funds manager, or you have a more complicated structure, or you're doing, private equity investments or things like that, it can be a challenge for you to be able to demonstrate, because the information from the underlying funds or companies might not necessarily be as readily available to you to be able to demonstrate that compliance. So I think it is a challenge for firms, and in particular in the U.S., where we don't, as you noted, have the legal obligation. I think there's a strong hope that at some point we come to sort of a common taxonomy, because it is, to Dan's point, a real challenge as you think about how to market your products and services within this framework across the world.
I think just to add to what Tracy said, we've been focused here on the product side of things, but there's a real challenge also with information and data to support these disclosures, not just in relation to products, but also on the entity level disclosures. The SFDR introduces this concept of principal adverse impacts of investment decisions, and managers will be required to make disclosures in relation to that. And I think one of the real challenges, and this will be more when the metrics become effective in the final RTS, is getting the data to support those disclosures. I mean, when the RTS was first written by ESMA and released, and it had all the different principal adverse impact indicators, half the industry couldn't meet it for. So it was really, I expect that data availability, particular data quality, to continue to be an issue. And I know that that's something that our trade associations are focused on as this evolves.
Yeah, and data quality and reliability of data has been a massive issue across the board in relation to ESG. And that's regardless of whether you are implementing an ESG framework in order to comply with SFDR, or whether you are implementing an ESG framework because your investors require you to do so. The data issue is the same regardless of why you're doing this. I'm sure many of you will have seen that there has been European proposals for some regulation around data providers recently, but that's obviously a very nascent issue, and we'll see where that comes to over time. And I feel that data quality is always improving, and the sources of that data is getting better. Obviously, there's still an enormous way to go. But yeah, we've certainly come away so far, and I don't know whether either of you two would agree with that.
Yeah, absolutely. And this is only going to continue as ESG becomes more and more prevalent. Clients are placing more demands on their asset managers. There is a need for data providers to provide better quality data, more accurate data. So I totally agree, Michelle. I think it's getting better, but there's a way to go, and data providers will need to kind of step up to the plate to meet the demands of managers and the industry as a whole.
Absolutely. And not just on the investment front, on the compliance front. One of the most challenging things to operationalize with anything like this is making sure that, to the extent that you're declaring yourself Article 8 or Article 9 or outside of the EU, if you have an ESG focused objective, is how do you ensure from a compliance perspective that you can demonstrate that you're meeting these requirements, or that your objective is in it of itself being satisfied.
Given the uncertainties that we've spoken about, particularly around the EU SFDR, in relation to your implementation work that each of your firms are doing, are you expecting this to be an iterative process? What you're going to put in place for the 10th of March is not necessarily what you are committing yourselves to be doing, perhaps even 12 months from now.
Absolutely. Absolutely. It is an iterative process. And, we expect that as more guidance comes out, as, data becomes available, as you can see what the industry is doing, what your peers are doing, I think it has to be an evolutionary process.
Yeah, I totally agree with that, and I think, or certainly what we're finding at T-Rowe is we've really got two implementation dates. We've got what we need to be compliant with the level 1, the sort of the principles, and then when the level 2 guidance, the regulatory technical standards, comes into force, that's going to mean that we're going to have to revisit a lot of what is in our prospectus, on our websites, in our reports, and we're actually going to think that that's going to be even more challenging in some ways, because those technical standards require so much more information. So I think you're going to certainly see disclosures for products and managers change fairly significantly between the 10th of March and the 1st of January next year. And then as the market kind of beds in, you'll probably see tweaks being made over time as well.
Okay. I want to just quickly move on to ESG from a UK focused perspective, just conscious of the fact we've got about 5 minutes left. With the UK, obviously, the UK is not implementing the EU SFDR. We were under no obligation to do so, given it has come into force post the end of the transition period. But that is not to say that the UK is doing nothing, and query whether the UK will come back to look at the SFDR or a version of it down the line. So work on sustainability measures has continued apace during the pandemic. I think in the run up to the COP26 later on this year, we're going to continue to see momentum building. We're going to continue to see the discourse in relation to sustainability in the UK. COP26 is very much going to focus minds on the need to deliver on tangible progress on initiatives, and new proposals are undoubtedly going to flow in relation to the facilitation of the flow of finance into more sustainable directions. On the topic of disclosures, one area that we're going to hear a lot about during the course of 2021 is the UK government's announcement in November 2020 to make TCFD aligned disclosures mandatory across the UK economy by 2025, with actually most of the work being done by 2023. The aim being to ensure that the right information on climate-related risks and opportunities is available across the investment chain, from companies through to financial services firms through to end investors. The UK was one of the first countries in the world to endorse the TCFD back in 2017, and in November the UK became the first country in the world to mandate TCFD aligned disclosure across the economy. We're awaiting a consultation paper in the UK from the UK FCA in relation to how these mandatory disclosures are going to apply to UK-based asset managers, with the biggest asset managers, those managing in excess of £50 billion, having to comply from January 2022, and all of the managers from January 2023. And the thing to note about the TCFD aligned disclosures in comparison to EU SFDR is that they are much narrower in scope, in that the TCFD is entirely focused on climate, whereas obviously SFDR is looking more broadly, not only at more broad environmental issues, but also the social issues as well, which is really why I say it may well be that the UK comes back to look at SFDR or a version of it going forwards. I'm very conscious of time. Just to open it up to the panel very quickly, any comments in relation to TCFD aligned disclosure and what your firms are looking at, or is it just too early at the moment given that we don't yet have the FCA consultation paper?
I think it's too early, but I also think that and hope that with all of these disclosure type of arrangements, that regulators are looking for some level of commonality. I think it's imperative for industry to be able to have a focused framework to be able to meet these obligations, which are all, of course, well understood. But I think that it is challenging for firms that are marketing on a global basis and providing services on a global basis to be able to make sure that their disclosures are meaningful but helpful, for investor protection principles. And having this fragmented framework makes it very challenging.
Thank you. Dan, any
I think the only thing
that
I would, the only thing that I would add to that, Michelle, I think what the UK has done has been quite shrewd. I think it was accepted by the industry until fairly recently that SFDR was going to be onshored. I think people were planning for that. But what the UK has done is they've seen the challenges that this has caused from an EU perspective with the implementation. I think they've taken a step back and thought, we'll focus our efforts on the environment side, on the climate side. And I think that they will see how the SFDR evolves in the EU and maybe cherry pick the best parts and avoid the pitfalls. to try and make the UK regime a little bit smoother. So I think that you're right, it will be looked at in future, but maybe just in a slightly different context from the UK angle.
Yeah, I agree with that. Now that brings us to time.